For a contract to exist in law, there needs to be an offer, acceptance of offer, intention to create legal relations, and finally consideration, all of which will be explained in this video. Dealing with the first element, offer, you need to be able to explain what an offer is, and it is a proposition or a suggestion by one or more persons to another. There are a couple of key terms you also need to be aware of. That's offeror, that's the person who makes an offer, as well as the offeree, the person who's receiving an offer. So be very careful not to confuse the two. You'll also, in the exam, need to be able to distinguish between an offer and an invitation to treat. Now, an invitation to treat is not the same as an offer, and there are some exceptions or examples to illustrate. So, for instance, articles displayed for sale in a shop window. In Fisher & Bell there were illegal flick knives on display in a shop window. That was inviting the customer to come into the shop and to make an offer, to put money down for whatever the knife was priced at. Or any articles on a shelf in a shop, such as in the Boots Chemist case. Advertisements are also an invitation to treat. So in Partridge and Crittenden there were some advertisements in a particular magazine for wild birds. They were considered to not be offers, but inviting people to make offers for those particular birds. And finally, auctions. And again, this is the auctioneer inviting an offer from somebody who wants to bid for a particular item, for example. Reward posters, on the other hand, are not invitations to treat, but offers. These are written documents on public view. Now, most commonly, when you think of reward posters, you might think something for returning a lost cat. So there'll be a picture of a cat, for instance, and it will say to anyone that sees this reward poster in public view, if you find my cat and return it to me at this address, then you will get this sum of money as a reward. So reward posters are in fact an offer. Now the key case we can use here as well is Carlill and Carbolic Smokeball Company. Not only does this case show that an offer can be made not just to one person or a group of people, but in fact the entire world even, and that's what happened in this case. Now, the Carbolic Smokeball Company produced a smokeball, and they said that whoever was to regularly follow the instructions and consume its vapours that it gave off would actually find themselves protected from suffering any ill health, such as influenza. And so confident were they that they actually put a reward out there in print saying that anyone who were using their product but became ill, they would give them a £100 reward. Now, of course, Mrs. Carlill did buy one, followed the instructions, nearly died when she contracted influenza, and then later when she tried to claim her reward of £100, they actually declined, so she took them to court and succeeded. Now, in terms of how that offer is communicated, generally speaking, any method will do, whether that's written, spoken, or by conduct. So, of course, it can be in writing. Somebody can say, would you buy my car for £500 or something like that. And by conduct, a good example that your textbook gives is by somebody going into a shop, for example a clothes shop, picking up a pair of jeans and walking to the till and starting that contract exchange. So either method's fine. However, the offeror can actually specify if only one or some of those is to be used. Now, of course, the offer, as I've said, can be to anyone in the world, and we've already heard about the Carlill and Carbolic Smokeball Company. But either way, the offer must be communicated effectively. In other words, for a person to accept it, they need to be aware of what that offer actually is. If by post, the offeror, making the offer, then effectively, when it arrives, the offer has been made. Now, in terms of the duration of the offer, how long can an offer actually exist? The offeror, the person making the offer, can actually stipulate when that offer will cease to be. So for example, it could be you have until next Tuesday to decide whether or not you want to accept my offer of £500 for whatever goods it may be. However, if an actual date isn't stipulated, then really the courts have decided that it's open for what is known as a reasonable amount of time. Now, of course, what's reasonable can depend on, for example, the goods in question or the service. So, for instance, if the goods were perishable, so if it were two market traders, for instance, and one of them offered to buy from the other some produce such as apples or some other fruit, then obviously a year later that's no longer going to be any good. Now the key case here is Ramsgate Victoria Hotel, and this one illustrates the point because the company Ramsgate were looking to issue some shares, and Montefiore actually sought to buy some shares from the company in June, but it didn't actually take place, the issue of the shares, until November, and the courts decided that actually the offer from Montefiore of buying the shares in November was no longer any good, and the offer had come to an end by that time. So finally, how can an offer cease to exist? Well, there are three ways that you need to be aware of for the exam. The first is revocation, or revoking the offer. Now this simply means the offeror, the person making the offer, can withdraw their offer at any time, but of course the person that the offer was originally made to, the offeree, must know about it. So obviously, for instance, by remaining silent, that won't actually be effective revocation. Now the key case here is Payne and Cave, which we saw earlier, and this helps support the point because in this case the person who was making a bid during an auction withdrew their bid before the auctioneer accepted it, so they revoked their offer. Now there's also rejection of an offer. So if an offer is made, it isn't certain that the person who it's been made to is going to accept, so the offeree is entitled to reject it. For example, if it's too much money, or they've decided they don't want to go ahead with the venture. And finally, a counter-offer. This is where the offeree, the person who the offer is being made to, refuses and makes their own offer instead. Now this could be, for example, where an offer is made and the offeree feels that that price is too much money and decides to make their own offer to the actual offeror, the original offeror. And this is what happened in the case of Hyde and Wrench. In this case, the defendant actually offered to sell his farm for £1,000, but the claimant initially thought the £1,000 was, £1,000 was too much money, so decided to counter it and say, well, I'll offer you £950 instead. Now this was rejected by the defendant, and then the claimant said, well, okay then, I'll buy it for the original asking price of £1,000. Now it went to court, and the court decided that as soon as the claimant countered and made their own offer of £950, which was lower, the original offer made by the offeror ceases to exist. So he in fact could not accept the original offer once he had made a counter offer. So it's well worth keeping in mind, a counter offer means the original offer ceases to exist. So now we're on to the important second element of what is recognised in law for a legally binding contract, and after offer comes acceptance, and that is firstly that an agreement to all terms of an offer must be made. So if there isn't agreement to all terms, it becomes a counter offer from the offeree, the person receiving the offer. A request for information before agreement is not an offer, so the key case here that supports this, Stevenson and McLean, and in this case where the claimant was offering iron for sale, the defendant, who in turn actually asked before accepting could the goods be bought on credit, that wasn't acceptance, that was just a request to ask for something, so there was no contract at that point. Acceptance must be by the person to whom the offer was made, so this really is common sense. If an offer is made, for example, but it's in earshot of somebody else, then obviously they can't jump in and say, I accept. So it's got to be whoever it's directed to. Usually any method of acceptance will do, although it can again be specified by the offeror that only one method or whatever may be done. And the key case here is Eliasson and Henshaw. In this case, flour was being offered for sale, but actually the offer itself had come from the wagoner, so it was a very old case, this, and it had to be that if the claimant wanted the actual flour, they had to pass that acceptance or message of acceptance onto the wagoner. They didn't. Instead what they did is they sent it by post. The wagoner actually returned back to the person who was offering the flour for sale. The acceptance had arrived by that point by post, but the courts decided that because it'd been specifically set out that acceptance had to be given to the wagoner, the employee, if you will, of the offeror, then it wasn't a valid contract. Now, in terms of how the acceptance should be communicated, acceptance must be communicated to the offeror. It is not possible to accept by silence, and the case supporting this is Feldhaus and Bindley. And in this case, an uncle was looking to buy a horse from his nephew. The uncle wrote a letter saying that if he heard no more, then he would consider the horse to be his. Now the nephew didn't reply, but the horse was accidentally sold off, which then led to the uncle suing the nephew. But the court decided that because the nephew hadn't actually said anything or written anything, there was no communication, he'd remained silent, there was in fact no contract and he couldn't sue. If acceptance is communicated by post, then there's a particular rule that applies. This is seen in the case of Adams and Lindsell. As soon as the acceptance, the letter of acceptance is posted, it is deemed to be effective, provided of course it's in post box or into the hands of a post office employee who's authorised to receive letters. So if it's given to anybody else, so for example, could you put this in the post for me, or you're hanging around somebody who let's say may work for the post office but isn't authorised to receive letters, and you just give it to them, whether they're standing by the post box or otherwise, then it won't count. If a letter is lost in the post, then the courts will deem it still to be effective, that acceptance has taken place, and this was shown in the Household Fire Insurance and Grant case. In this particular case it involved the purchase of shares in a company. The person in question wrote to the company offering to buy shares. Acceptance, or a letter of acceptance, was posted to him, but he never actually received it, and then when the company went into liquidation later in a bit of trouble, he actually had to bear the cost of those shares. Now his argument was, yes, I made an offer to purchase shares, but I never got a reply back. Well, in fact, when the company had put the letter of acceptance into the post, even though it went missing, it was still deemed to be acceptance and a contract existed. Now modern methods such as email are almost instantaneous, so as soon as the person presses send on their computer or otherwise, then it's deemed to have arrived. And the case that supports that is in Torres and Mars Far East. However, if the acceptance in an email is received out of office hours, such as a Saturday or a Sunday or whatever, then of course the case of Brinkebom Limited and Starhag Stahl shows us that it will be effective the next working day. Now we come to the third of those important elements when the law recognises a legally binding contract, the intention to create legal relations between the party. Now this simply breaks down as two things if you're asked this in the exam, and that is there are two settings or situations where the courts recognise agreements to take place. And the first we have is business and commercial agreements, and the courts presume that these are legally binding. And this is quite sort of common sense really, because if you think about the money that may be involved and the risk and so forth, if the person doesn't actually comply with the agreement. So we can see that in the supporting case of McGowan and Radio Buxton. And in this case, claimant entered a competition on the radio to win a car. They were told that they won the car, and in fact received instead a 4-inch scale model of the vehicle. So you can imagine they weren't best pleased. The defence argued there was no legally binding contract, but the courts held otherwise. Having said that, there are situations the courts will accept where the parties, or can provide evidence to rebut this, to essentially say, well, it was a business or commercial agreement, but we never intended it to be legally binding and for it to go to court. And the key case here is Rose and Frank Co. And Crompton. And in this particular case, the evidence was quite clear because the parties had included in their written agreement the words, "This agreement is not entered into as a formal or legal agreement and shall not be subject to legal jurisdiction in the law courts." So in other words, they were both saying, we enter this agreement, but we don't want it to be settled in the courts. You've also got the phrase you might come across, binding in honour only, which is a strange one. Effectively, the courts see that as not being legally binding. The case that supports this is Appleson and Littlewood. So this is a phrase that is usually used on football pools entries and means where a person enters a football pools competition, they're agreeing not to be held bound legally to the contract between them and the pools company. So in fact, if they do win any money on the pools, the company isn't bound in law to pay out. So the person cannot sue if those words are present, and that was what happened in the case with Appleson and Littlewood. Now, finally, the other setting that the courts recognise, or situation, is domestic and social agreements. And the courts take the general view here initially. They presume them not to be legally binding. So here we're talking about agreements between friends, spouses, family members. So for example, if your mother said to you, if you pass your A levels, if you get an A, I'll pay you £100, and if you get a B, I'll pay you £80, and so on. And you get an A in your exam, and then your mother refuses to pay. You can't take her to court and sue her. We can see this in the supporting case of Balfour and Balfour. A very famous case. In this case, the husband, who was working in Sri Lanka, now he agreed to pay his wife £30 a month when she was unable to go with him because she was ill. He actually stopped paying the £30, the husband, and so the wife unfortunately wasn't able to sue him in the courts because it was held just to be a domestic agreement. However, much like the business and commercial agreements, if there's any evidence that suggests otherwise, this can rebut this presumption. And that's what we see in the supporting case of Merit and Merit. And in this case, again, we have a husband and wife situation, but here the husband had left his wife for another woman. The husband and wife agreed that the husband would pay some income to the wife so that they could pay the mortgage on their former home. Of course, when he refused to pay some or all of that money, she took him to court, and it was, the courts saw an intention to create legal relations, and it was a legally binding agreement in that case. Okay, and now the final part of what makes a legally binding contract, the element known as consideration. So in the exam you'll be asked to define or explain what that means, and that's simply what each party puts into the contract. So for instance, it could be goods, services, money, or even to stop doing something. So you can think of typical scenarios you might get. Could it be, for instance, a nightclub owner who offers a sum of money to a singer or a DJ to provide a service, or a person who is a homeowner and contacts a building company for them to build an extension onto their house for a certain sum of money. So again, those sort of situations. It must have some value though, so the law will not recognise something that's done for nothing. And that's why commonly you see, even in the news, you hear about businesses being sold for £1 to somebody. So for it to be legally binding, there must be some value. Of course, when we're talking about businesses and things, though it may seem £1 is too good to be true, they're also inheriting perhaps all the debts and so forth that business may entail. Now, for it to be real, tangible, a good case to illustrate this is Chappell & Co. and Nestle Limited, where the House of Lords decided that tokens on sweet wrappers by the Nestle company, which said that if you sent in 3 tokens plus some money, you'd get a music record. That was real. That was good consideration. Things that are intangible, things that are not real, not acceptable, are a bit vague. We can see that in the case of White and Blewett. In this case, the son owed his father a sum of money. When the father died, the debtors tried to claim that money back from the son, the debt. And the son said, well, he had entered into an agreement with his father that he would not have to pay this sum of money back if he didn't complain about the assets in his will and how they'd be distributed upon his death. But the courts decided that was much too vague. And finally, past consideration is not acceptable. And this is seen in the key case of Ree McArdle, where a widow was left a house which she wanted to pass on to her family, the beneficiaries. She made a number of improvements and repairs, decorated the property, and the children actually promised her that they would help with this and in turn get the house. They didn't, and so when she died, all the improvements to the house had already been made, and so therefore they had put no consideration of value into the contract, and they didn't get the property. You also need to be aware of what happens if there's a breach of contract by one of the parties, and this is a question that will be in the exam. So a breach of contract can be done by an actual breach or anticipatory breach. So dealing with the actual breach first, this can be done through one of 2 ways. The first is non-performance. So for example, as we said earlier, a nightclub owner contracts a singer to arrive at a particular event at a set date in the future to perform, and they fail to do so. And the key case to illustrate this is Pilbrow and Peerless de Rougemont & Co. And in this example, a man arranged to see a solicitor for some legal advice, but when he arrived at the solicitor's office, his case wasn't actually heard by a solicitor, but by somebody else employed at the office. Now, when he refused to pay his bill because he hadn't seen the solicitor that he wanted, they tried to sue him for the money, and the court agreed that they hadn't performed what they were supposed to do. And the second one there, improper performance. So here what we're looking at is where the contract is performed, but not to the standard that it should be. And so the key case here is Bunge Corporation and Tradex Export SA. Here, a buyer was required by the contract to give at least 15 days notice of readiness to load a ship. But in fact, 15 days notice wasn't given. The buyer only gave 13 days notice, and so therefore hadn't performed the contract correctly. And then that second situation that could amount to breach of contract, anticipatory breach. Here it's where in contracts there's an agreement to do something in the future, but they fail to do so. So if we look at the case of Hoxter and Delatour, what we have here is a man who was hired to work as a courier, and the work was due to start in 2 months after the contract had been made, but 1 month in, the defendants actually wrote to the man cancelling the contract, saying that it would not be performed, and so therefore this was an anticipatory breach. It's important to note that the innocent party here doesn't actually have to wait until the date of the contract for that particular thing to be performed. They can actually sue straight away if there's an anticipatory breach. Now, if breach of contract has occurred, then the innocent party will be looking for damages, most often than not. In other words, a sum of money to be awarded by the courts, aiming to put the claimant in the same position as if the contract had not been broken, compensating for any loss. And so when we talk about loss, loss can occur in a number of ways depending on the contract. So looking at some cases here, if we start with Stansby and Troman, here the loss was the value of goods stolen. In Anglia Television and Reed, where we had a television company actually doing some preparatory work before they started shooting with this particular actor. When the actor pulled out, therefore their loss was the preparatory work that had been done. And then finally in Victoria Laundry and Newman Industries Limited, here we had a loss of profits. But it's also important to not forget causation, and this is a question of fact as to whether the breach has been the main cause of the loss. If the loss arises partly from the breach and partly as the result of intervening events, the party in breach may still be liable, provided that the chain of causation is not broken. However, when looking to compensate the innocent party, the courts will not accept any claims that are too remote. In other words, where really a claim doesn't arise. And the key case for this is Hadley and Baxendale. And here the claimant owned a mill and ordered a new driving shaft for it to be delivered by the defendant. However, the defendant was actually late in delivering this, and the claimant sued for breach of contract. The claimant tried to claim for loss of profit as the mill had been out of action while waiting for this part, and it was held that the defendant didn't know that the mill could not operate without the shaft, and therefore wasn't aware of loss of profits. So the loss of profits aspect of the claim was too remote. They came up with two key questions in deciding whether or not a claim should be successful and isn't too remote, and this is that the damages should be awarded where they arose naturally from the breach of contract, or they were reasonably in contemplation of both parties when the contract was made. So if the mill owner had told the defendant that quick delivery was important because if not the mill wouldn't be operating and he would be at a loss in terms of profits and so forth, then it would have reasonably been in the mind of the defendant, and perhaps then damages could have been awarded. But because he wasn't aware that the mill would be closed during this period, the claim wasn't successful. And if we just also look at the book, and one of the cases we looked at earlier, Anglia Television and Reed, when the actor made a contract with the claimants to star in a television film, when the claimants, the television company, actually spent money on preparatory work, and the actor broke the contract by saying he was no longer wanting to do it, they were unable to find a replacement. So all of that wasted money was something that they sued the defendant, the actor, for. And the court said that the actor must have realised, in other words, must have reasonably in contemplation of the actor, that by pulling out at that stage, that the television company, Anglia, were at a loss and should be awarded damages. Mitigation of loss. This is where the innocent party takes reasonable steps to minimise loss, and we can see that in the case of British Westinghouse and Manufacturing Co Limited. In this case, British Westinghouse had contracted to supply turbines to underground electric railways. However, when underground electric railways received the turbines, they weren't to the specification that they'd contracted for, and so as a result, to try and mitigate their loss, they actually bought some turbines from someone else, and it cost a great deal more money, so therefore they were compensated for it. Now, in terms of mitigation of loss, if it's an anticipatory breach, the innocent party has a choice. They can sue for damages straight away. There's no need to wait until the date of performance. So for example, you might see something in the exam where, if it were, say, in the scenario, a nightclub owner who's contracting a singer to perform at a gig at a certain day and time, and they suspect or are told by the singer that they're not going to perform, then they can sue the singer straight away. However, a second option is to continue with the contract and then claim for loss caused due to breach. And we can see this in the case of White and Carter Limited and McGregor. Here we had the defendant who owned a garage and entered into a contract for advertising of his business to be placed on litter bins for a local council for a 3-year period. However, he then changed his mind. Now, they could have sued the claimant straight away. Sorry, they could have sued the defendant straight away, but instead they went ahead with the work that they'd done for preparing these advertisements, and then claimed for the cost of all the work in preparing for them. So even though the cost of it had been incurred after the defendant told them he was not going ahead with the contract, they were compensated for that. And that's the end for the topic contract law. Thank you for listening.